Good morning. First, for discussing topics for the preparation of exam, today we will discuss transfer petitions. See, for criminal proceedings, transfer petition provisions are available from 406, 407, 408, 409, 410. 406 for Supreme Court, 407 for High Court, 408 Sessions Court, 409 and 410 within magistrate, Chief Judicial Magistrate. See, the problem was that provision is time to time interpreted, and whether you can go concurrently straight away or not, these all are time to time. 406 Supreme Court power, 407 High Court power, transfer of appeal as well as other things. 408 for Sessions Court, 409 withdrawal of cases and appeal by session judge. The district session judge suo motu can withdraw it. Then withdrawal by judicial magistrate, chief judicial magistrate power. Then executive magistrate is also having same power. This for this transfer petition you should file proof affidavit only. Without affidavit, transfer petition may not be entertained. There are two categories of transfer petition. Number one, allegation against the proceedings or presiding officer. Other one is convenient of the parties. So for civil is concerned, section 24 deals with CPs deals with the transfer of petitions. Nowadays, family court, since is not being conducted as per Code of Criminal Procedure exclusively, transfer petitions are being filed under section 24 and before Supreme Court. Now, what I would like to say, periodically the Supreme Court and other High Court was conveniently transferring the family court matters for the convenience of wives. Here, the first time, not only first time, probably there may be some other cases also. The Supreme Court in year 2023, 2106, 2106, Delma Lubna Coelho versus Edmund Client Fernandez case. The wife have no issues, substantially earning, and periodically traveling locomotively from India to Canada. Therefore, they say it need not be transferred. And for so many reasons, they say for litigation expenses, travel expenses, she may apply the lower court, and that should be decided on merit. Therefore, they have also said if you want to conduct the cases by video conferencing. So Sandini versus Vijay V. Venkatesh 2018, 1 SEC 1 AAR 2007 SC 5745 may be followed. That's what they say. You may better. Now I have completed that discussion. Now I would like to congratulate all of young lawyers that recent judgment of Justice S.M. Subramaniam that the Bar Association may not consider that they are the superior Bar Association. But before that, I would like to have a discussion about the history of our courts. See, earlier there were three Supreme Courts: Delhi, Bombay, Calcutta. That was the Supreme Court of India. You can, when you are have time to just to wander within the court premises, you go to Court Hall 3, 4, 5, where you can find the name of the judges showing as Supreme Court judges. Then thereafter only our High Court was constituted, and from there onwards the High Court of Judicature Madras was constituted. Initially at Madras High Court, there is only one bar association, that is consisting bar at law members only. They did not allow native advocates to argue before the High Court. Thereafter only they have allowed non-barrister advocate also to practice. Therefore, they have started another association called Advocate Association. Now we call it MHA. It was not that time. The title of association was Advocate Association. This Advocate Association was registered under Cooperative Societies Act, Colonial Act. Therefore, there shall be a president and two secretaries, no librarian, and there may not be any treasurer or other things. That one of the secretary will retire for routine time, 2 years once. He will be the election officer. This is the way the elections are being conducted. But later on, at instance of me, by filing suit 301, the present Advocate Association is regulated by constituted committee for framing bylaws, headed by Rajagopalan, Senior Counsel, and Justice P.T. Asha, Chandrakumar, and so many persons. And we went up to Supreme Court when it was challenged by a few members, and finally the present Advocate Association is regulated by the scheme degree, and that is also now challenged. I do not know whether they want to continue the degree. Anybody is referring the scheme degree or not. Let us hope and wait. Now they say because it was consisting barristers, slowly they also admitted advocates. Particularly all they have got somewhat behave like Senate, Lords Club. But they slowly, I know when one of the leader, I do not want to mention name, he was fighting with Mohandas, Advocate Mohandas, who was prevented from taking drinking water, and huge hue and cry was there in MHA that this MBA should be annexed. Later on, what had happened, the very same leader was admitted as a member of the MBA. Therefore, he left that. This is the way even our leaders betray us. Thereafter, now it's astonishingly, one more thing is that MBA has no bylaws registered, nor the association was registered one. But one thing is sure, that the association is not self-financed association, rent-free, electricity-free association. Therefore, it is part and parcel of the administration of justice under the control of our High Court of Judicature. When I have filed a suit, writ petition against MHA president who typed resolution at his home and affixed in the notice board, then it was objected, stating that no locus standi, court has got no jurisdiction. My only ground was that it is part and parcel of the administration of justice. The association was to station the advocates for their judicial work and assisting the court. Therefore, the functioning of the said advocate association is directly or indirectly hindering and interfering with the administration of justice. The writ petition was maintainable. That writ petition was held maintainable. All the resolution passed by the then president was declared null and void, non-est. Okay, this time we have to thank Justice S.M. Subramaniam that every advocate can be a member of the Madras Bar Association. Let us see what they are further doing. And nowadays, this Madras Bar Association is being governed by best persons. I don't think they will have any objection for these rulings. And this is a very landmark welcome because This MHA consisting of a large number of the persons and facilities are not sufficient. But MBA is consisting of wealthy persons. Therefore, they have a lot of high technology devices to get knowledge and to work with the judiciary at par with their own technicalities. Okay, best wishes.